Court finds that the parties are incompatible and that the petitioner shall be granted a final decree of divorce from the respondent on the legal ground of incompatibility. The marriage of the parties is hereby declared to be dissolved. The court
A
does
Kansas divorce hearing begins, and while most issues seem settled between Christopher Jones and Brianna Salinas, one critical battle remains: child support. That single number could change everything. But is this just a delay tactic or a real dispute? Stay tuned as tension builds. Subscribe now for more intense courtroom drama.
County, Kansas case entitled In the Matter of the Marriage of Christopher E. Jones and Brianna L. Jones, otherwise known as Brianna L. Salinas, case number 2025 DM 287. Beginning with petitioner, would counsel announce their appearances for the record, please?
Joshua Andrews on behalf of the petitioner Christopher Jones, who is also present remotely for the Zoom hearing.
Your Honor, may I please the court attorney Lauren Schooler on behalf of the respondent who is present via Zoom separate from counsel.
Thank you. Mr. Andrews, what is the current status of this case?
Your Honor, if I understand correctly, and Ms. Schooler, correct me if I am mistaken, I believe we have a settlement agreement on everything except for the amount of child support. We are still working on resolving that issue. I received an email. I had sent a updated proposed worksheet to Ms. Schooler yesterday, and she had sent back an email indicating that they believe the income number I have for Ms. Salinas is incorrect, and so I'm just needing to follow up with some additional information to try to nail down what the correct income number is, and then the child support will be, what the guidelines say it is, but we don't have that number agreed upon today. It sounds like we have everything else agreed upon regarding division of assets and debts, and custody and residency and parenting time.
Okay, Ms. Schooler, what is your assessment of the reason why you can't agree on an income number for your client?
Your Honor, her income, I'm not sure that I had sent the newest newest pay stubs to Mr. Andrews, to be quite honest. So I did send those to him this morning. She had changed jobs not that long ago, and she's also working part-time, and she's also working for a school. So not only are we dealing with part-time work, but we're also dealing with that typical teacher schedule where they're not employed really the whole year, but trying to figure out what the income would be for the child support worksheet. So I think our primary focus was mostly the house and the assets and stuff like that. So we just need to iron out the last little wrinkle of child support.
Strangers, what do you propose regarding actions or actions not to be taken today?
Your Honor, I would defer to the court, but I would be comfortable essentially putting the final divorce on the record with the provision regarding child support, just simply stating that child support to be determined based upon the child support guidelines. And if for some reason Ms. Schooler and I are not able to reach an agreement, setting that for a brief hearing just on that issue, but putting everything else on the record today with the hopes that we're able to reach an agreement on the child support, and then just be able to circulate a journal entry and file that with the court once we've got that issue resolved.
Would you be in agreement with that proposed procedure, Ms. Schooler?
Yes, Your Honor.
All right, very well. Then you may proceed further, Mr. Andrews.
Thank you, Your Honor. Your Honor, I will call Christopher Jones to testify regarding the grounds for the divorce and our understanding of the agreement.
All right, Mr. Jones?
Yes, can you hear me?
Yes, I'm going to swear you in at this time. Raise your right hand, please. You do solemnly swear that the testimony you're about to give in the matter now in hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
You may question the witness, Mr. Andrews.
Thank you, Your Honor. Christopher, please state your name for the record.
Christopher Jones.
And Mr. Jones, you are the petitioner in this case, correct?
Correct.
And were you a resident of the state of Kansas for at least 60 days prior to filing the petition for divorce?
Yes, I was.
Did you and Brianna Jones, also known as Brianna Salinas, establish a marriage by common law as of August 2019, in that the two of you had the capacity to marry? The two of you agreed to be married, and you held each other out to the public as being married from that time?
That's correct.
Do you believe that the two of you are compatible to remain husband and wife at this time?
No, I do not.
Do you believe that is going to change in the foreseeable future?
I do not.
Is this incompatibility based upon irreconcilable differences between the two of you?
It is.
Are you requesting an absolute decree of divorce from Brianna based upon your incompatibility?
Yes, I am.
You and Brianna have two minor children, correct?
Correct.
Have you entered into an agreement regarding the care, custody, and support of the minor children?
Yes.
And this agreement is essentially to continue with the residency and parenting time that was recommended by the guardian ad litem and set forth specifically in an order modifying residency and parenting time filed on March 6, 2026, correct?
Yes.
You are not seeking any revisions to the parenting plan contained in that order, and would be asking the court to adopt that order as the final order of the court in this matter. Is that correct?
I am.
You've also entered into an agreement regarding holiday parenting time that was set forth in a written holiday parenting plan that has been signed by you and myself, and will be signed by Ms. Schooler and her client and filed with the court.
Correct.
And again, you're not seeking any revisions or modifications to that holiday parenting plan in the final orders, and would be asking the court to adopt that as the final orders of the court as well. Is that correct?
That's correct.
And then finally, are you asking that the court establish child support consistent with the child support guidelines once the parties have determined the appropriate income number for Brianna to be used in that child support worksheet?
Yes.
Do you believe that your proposed orders and this agreement is in the best interest of the minor children?
I do.
Now, we're deep into asset division, and notice how detailed and structured this agreement is. Real estate, bank accounts, even retirement funds are clearly assigned. That usually signals cooperation. But here's the twist. If they agreed on everything else so smoothly, why is child support still unresolved? What do you think is really causing this delay?
Have you also entered into an agreement, as you understand it, regarding the issues of spousal support and the division of marital assets and debts?
It's filed. Yes, I believe.
Specifically, is it your understanding that there is an agreement that neither party will owe a spousal support obligation?
Right. Correct.
And have you also agreed that you will be awarded as your sole and separate property the your half interest in the real estate commonly known as 1606 Edgemore Street, El Dorado, Kansas?
I guess I'm confused by what that means.
The real estate at 1606 Edgemore Street, El Dorado, Kansas, is owned in part by you and by your father. Is that correct?
Correct.
All right. So you have a half interest in that real estate, and your father has the other half interest in that real estate?
Yeah, I think. Yeah.
Okay. And you have agreed that you will be awarded any and all interest that you have in that real estate will be awarded to you. Is that correct?
Right. Yeah. Correct.
And you've also agreed that you will be awarded as your sole and separate property your Amazon 401k plan, Fidelity investment account, Fidelity restricted stock, 2012 Nissan Pathfinder, Emprise Bank account, accounts ending in 0106, 2985, 2011 and the White Eagle Credit Union checking and savings accounts.
Yes.
And you've also agreed that you'll be awarded any other personal property that's not otherwise specified that is currently in your possession and control.
Correct.
And have you also agreed that Brianna will be awarded as her sole and separate property, her capers, the 2024 Hyundai Sonata, and the Emprise Bank account ending in 4713,
Yes.
as well as any other personal property that's in her possession or control that's not otherwise specified?
Correct.
Then have you also agreed that you will assume sole obligation of the two Credit One credit cards, Bank of America credit card, Chase credit card, and Capital One credit card ending in 6067,
Yes.
as well as any other debts or financial obligations that are incurred in your individual name or were incurred by you since your separation, you and Brianna's separation, that are not otherwise specified?
That's correct.
And have you also agreed that Brianna would be awarded as her sole and separate property the Hyundai Motor Finance loan, the Capital One credit cards ending in 3496 and 8601, the Victoria's Secret credit card, Old Navy credit card, Best Buy credit card, and Lowe's credit card?
That's correct.
And have you also agreed that she would be solely obligated for any debts in her individual name or that were incurred by her since the separation that are not otherwise specified?
Yes.
Do you believe that the terms of this agreement are fair, just, and equitable?
I do.
Are you asking that the court adopt this as the final orders of the court at this time?
Yes.
Your Honor, I have no further questions.
All right, Ms. Schooler, do you have any further questions for this witness?
No, Your Honor.
All right, do you intend to present any further evidence, Mr. Andrews?
No, Your Honor.
All right. Ms. Schooler, do you intend to present evidence at this hearing?
I did not, Your Honor.
All right, very well. Court has reviewed the file in this case and has heard the evidence that's been presented in the case. Court finds that the parties are incompatible and that the petitioner shall be granted a final decree of divorce from the respondent on the legal ground of incompatibility. The marriage of the parties is hereby declared to be dissolved. The court does find that the parenting plan, which was essentially suggested by the guardian ad litem and adopted by prior order, should be continued and is consistent with the best interest of the minor children. Court does note that there is a child support issue which remains in this case. Court finds that the parties' agreements regarding property and debt should be adopted as the orders of this court as being fair, just, and equitable to both sides. Point out to the parties that under the laws of the state of Kansas, you're not divorced based on this oral pronouncement from the bench, but rather when the decree of divorce eventually gets done, approved by the court and then filed with the clerk's office. It's the filing of the divorce decree, which is the act that divorces you under Kansas law. And then for a period of 30 days thereafter, you should not try to remarry. Any marriage you would attempt to enter into during that 30-day period would be voidable under Kansas law. So wait at least 30 days past your decree's eventual filing date to attempt to enter into a new marital relationship. The court trusts that reasonable attorneys and parties should be able to resolve the remaining issue of child support. It's just a question of getting the wife's child support amount for income correct so that the worksheet can be completed. I'm going to trust that the attorneys are going to be able to accomplish that in the near future, and I hope that there's not a long delay. Counsel, if you can't get that child support order finalized, then we need to set another hearing to resolve that issue. But again, I'll just wait for what I anticipate to be an agreed upon decree in all material respects. Mr. Andrews, is there anything else that we need to address currently?
Not at this time, Your Honor.
Ms. Schooler, anything further that the court needs to address?
No, Your Honor.
All right. Good luck to both parties in the future, especially when it comes to working together for the best interest of their kids. If there's nothing further.
The judge finalizes the divorce, approves custody and property agreements, and leaves child support hanging on one missing income figure. Everything hinges on that last detail. It's a clean ending, but not fully complete. Want more real courtroom breakdowns like this? Like, share, and subscribe to stay updated on every twist.